Welcome to you all. My name is Chantal Bernier. I lead the privacy and cybersecurity practice for Dentons Canada. And I'm joined this morning by my colleague, Amanda Branch, who is a senior associate in the Ottawa office and a member of the privacy and security team, and has been invaluable since her arrival in the firm about 5 months ago, as well as by my colleague, Marc Elshof. Marc Elshof is a partner in our Amsterdam office and our go-to person on so many European law issues, including the Standard Contractual Clauses. He is the co-lead for privacy and security, data protection security in Europe. And as we so often benefit from his advice internally, we thought, Amanda and I thought that we would share him with you, so to speak, today to help us understand the impact of the new EU Standard Contractual Clauses for Canadian businesses. The idea came to us as we received so many client requests, and the fact that there are almost 500 of you on the line shows that clearly this is of great interest. So first of all, welcome Amanda and Marc. Thank you for leading us through this. I will not speak further than to share with you 3 housekeeping messages. The first one is that this is recorded so that we can actually share it with you when other materials are also available. Secondly, you can ask your questions in the chat. I'm going to go off camera and on mute, and I will monitor the questions. And finally, you can get credits for 60 minutes from the British Columbia Law Society, Ontario Law Society, and the Quebec Bar. So without further ado, I'm going to turn it to Amanda to engage in a conversation with Marc to help us understand the impact of the new Standard Contractual Clauses for Canadian businesses.
Great, thank you very much, Chantal. So to set the stage as to why these standard contractual clauses matter to Canadian businesses. So the European Commission has the power to determine whether a country outside the EU offers an adequate level of data protection. A decision of adequacy means that the personal information can flow from the EU to that country without any further safeguards being necessary, such as the use of standard contractual clauses. So Canada has had partial adequacy status since the early 2000s, when a decision was rendered stating that Canada is considered as providing an adequate level of protection for personal information transferred from the EU to organizations that are subject to PIPEDA. So as we know, PIPEDA applies to private sector organizations that collect, use, or disclose personal information in the course of commercial activity. It also applies to federally regulated businesses like banks, airlines, and telecommunication companies. So Alberta, British Columbia, and Quebec have their own private sector privacy laws that have been deemed substantially similar to PIPEDA. So organizations subject to a substantially similar provincial privacy law are generally exempt from PIPEDA with respect to the collection, use, or disclosure of personal information that occurs within the province. So while the provincial legislation is deemed substantially similar to PIPEDA, that legislation has not been deemed as adequate. So only PIPEDA has adequacy. So in light of that, when would a transfer of EU data towards a Canadian company trigger the need to use the standard contractual clauses? So one example is in the event that the transfer is to a Canadian organization that is not subject to PIPEDA. And another would be in the case where the transfer is to a Canadian organization that's subject to PIPEDA, but that organization transfers the data onwards to a country that does not have adequacy status. So for example, if a Canadian company transfers data to the US for storage. So I appreciate this is a little complicated, but that's why we have Marc here with us today to help us unravel all of this and give us further details on the standard contractual clauses.
Thanks very much, Amanda, and thanks to you and to Chantal for inviting me on today's webinar. True pleasure to speak to so many of our Canadian friends. So if we could move to the next slide, please. So part of this Amanda already covered. Again, and that's important to realize. So the GDPR is sort of this walled garden or safe harbor protecting data within the EU. So within the EU, data can flow freely between countries, but as soon as you want to transfer data outside the European Union, additional safeguards must be in place. As Amanda said, this can be done by the European Commission if it rules that a country or a territory within the country is adequate. And otherwise, the GDPR has an exhaustive list of transfer mechanisms that the data exporter should then choose from to be allowed to transfer its data outside of the European Union. And the most used of these transfer mechanisms or transfer safeguards are the standard contractual clauses. Now, what are the standard contractual clauses, or the SCCs, as I will call them from now on? It's a bit shorter. They are contractual arrangements between a data exporter and a data importer, and the aim of the SCCs is to raise the level of data protection at the importer end by imposing contractual obligations on the importer that are the same or similar to the obligations that the exporter has under the GDPR, and that a recipient in the European Union would have if it would receive information from the exporter. And this means that if the data exporter and data importer execute the SCCs, then that data can flow to the importer, despite the data importer being in a country that is not adequate. There are some complications ever since the Schrems II decision of last year, a year and a half ago, and so we'll address those a bit further down. But this is in essence the rule. And what's important, and that's a question we get asked often: can we change the SCCs? No, you may not change them. They must be executed unchanged, and parties are allowed to add commercial provisions, for example, or additional safeguards, but only if they do not conflict with the clauses of the SCCs. SCCs have been around for quite a long time, and in June 2021, if you could move to the next slide, please, the European Commission issued new SCCs. And why was that? For three main reasons. First of all, the SCCs until then referred to the GDPR's predecessor. They predated the GDPR, and they still referenced the privacy directive. And also they had a fairly limited scope, and certain common transfer situations were not covered by the old SCCs. For example, a processor in the European Union that engaged a sub-processor outside the European Union could not rely on the old SCCs because there was no processor to sub-processor SCCs. Or a processor in the European Union that was engaged by a controller, by a customer outside of the European Union, that service provider in the European Union could not send back the data to its customer outside the European Union because the old SCCs didn't allow for that. And thirdly, Schrems II, I mentioned it, and you may or may not have heard of it, but it's a judgment, an infamous judgment by now, the European Court of Justice, and the consequences of it cannot be overstated for the privacy world. But it basically, in that decision, the European Court of Justice ruled, first of all, that the EU-US privacy shield was no longer valid, could no longer be relied on for data transfers from the EU to the US. But it also ruled that while the SCCs were in principle a valid transfer mechanism, so they could still be used, it was incumbent on the controller, on the exporter, to do a case-by-case analysis of, in particular, the surveillance laws in the country of the importer, and assess if there was anything in those laws that could impinge on the protection offered by the SCCs. This has been a massive headache for companies operating across borders, and it continues to be a massive headache. I will dive into it in a bit more detail, but these are in essence the three reasons why the European Commission adopted the new SCCs. Move to the next slide, please. Here's a very brief timeline of these new SCCs. So as I said, in June 2021, the new SCCs became applicable. So from that day on, they could be used. 27th September of last year, that was the deadline for the new SCCs to be used for new transfers. So if a data export in the European Union would engage, for example, a new service provider outside of the European Union, then from that moment on, it had to use the new SCCs and could no longer rely on the old SCCs. We are now in the middle of the transition period, and it's the time to transition to the new SCCs, and this period allows the organization to transition over to the new SCCs for existing transfers. So for transfers that already existed on 27 September 2021, they can for now continue to go ahead on the basis of the old SCCs. But on 27 December of this year, the new SCCs must be used for all data transfers. So I, for one, will not be making many plans for Christmas this year, I think. A quick comment on the UK, because UK left the European Union. So the new SCCs do not automatically apply in the UK. The UK has not yet adopted new SCCs, meaning that the old SCCs remain approved and can be used. But what we see in practice is that companies use the new EU SCCs also for transfers from the UK. Now, strictly speaking, that would be non-compliant, but we cannot see a situation where the ICO would take enforcement actions against this practice, because the level of protection offered by the new SCCs is substantially higher than that offered by the old SCCs. So in practice, what we see is that companies combine transfers from the EU and transfers from the UK through the new SCCs. Next slide, please. What's important to understand is that the new SCCs have extraterritorial applicability, which means, on the one hand, that they can be used by data exporters that are outside the European Union, but whose processing activities come under the GDPR. For example, because they offer goods or services targeted at individuals in the European Union. And what's also important to understand is that the GDPR concept of a data export is not necessarily used in a geographical way, but in the way that if the data leaves the safe harbor or the walled garden of the GDPR, a transfer safeguard is necessary. And this means that a data exporter who's outside the European Union, but whose processing activities come under the GDPR, and that exporter uses a sub-processor or a processor in another non-EU country, they must execute the SCCs. So let me give an example. A Canadian travel company selling road trips across Canada targets this service to individuals in the European. It actively tries and sell those road trips to Europeans. This means, let's assume that this means that the processing of personal data related to those services is captured by the GDPR. The company uses a processor in Mexico to send its monthly marketing newsletter. This means that for the transfer from Canada to Mexico, the Canadian company and the Mexican company must sign the SCCs. And what's important is that the data importer, when signing the SCCs, agrees to be subject to the jurisdiction of EU supervisory authorities. And you can already feel that in the scenario that I just described, where a Canadian company and a Mexican company enter into a contract for certain services, the idea that the Canadian company must impose the SCCs on this Mexican company may lead to challenging discussions with your vendor. And another complex and not yet fully crystallized area is the use of SCCs for between a data exporter, covered by GDPR of course, and a non-EU data importer that's also subject to the GDPR. There is a recital in the SCCs that where the European Commission states that the SCCs cannot be used in this scenario. And very recently, the European Data Protection Board, which is a body comprised of all the EU data protection supervisory authorities, reiterated that position and said that the SCCs cannot be used in that scenario because the SCCs aren't intended for use between two GDPR covered companies. However, and that's where this hits the real world, there is no real alternative. There are no SCCs light, if you will, that would cover that situation. And there are other transfer mechanisms in the GDPR, but they are limited to very specific situations or require a massive undertaking on behalf of the importer or the exporter, and that's if they want to set up binding corporate rules. So for now, yeah, the supervisory authorities sort of leave it to the market to sort it out for themselves. But this is an area, yeah, that we need to watch and see how it develops. I understand that the European Commission will work on sort of SCCs light to solve this issue, but for now it's a problem in practice. Next slide, please. Because I wanted to address, after setting this scene and as to the territorial applicability and as to why you can see this can also be relevant for Canadian companies, even if they are covered by, they come under PIPEDA. I want to briefly touch upon some of the key points of the new SCCs and then move to more practical points on how to operationalize new SCCs. I already said that the old SCCs lacked the flexibility in that they didn't cover some transfer scenarios that are used in practice very often. And the new SCCs quite effectively, I must say, solve that issue. And they take a modular approach. There are 4 modules, so that there's a brief general section, and then there are 4 modules. And the 4 modules are controller to controller, controller to processor, processor to processor, and processor to controller. And what you can do is you can basically select the right module only add that wording to your contract as an annex, for example, and that's that. And this covers, I would say, 98% of all the transfer situations. So that's a very big improvement from the old SCCs. Also, the new SCCs expressly stipulate now that you can add multiple parties or add new parties to existing SCCs. That was common practice under the old SCCs, but they didn't expressly allow for it. So it was a bit of a gray area as to whether it was possible or not. But now the SCCs have a clear docketing clause stating that new parties can sign up to already existing SCCs. Thirdly, you do not need a separate data processing agreement if you have a controller to processor or a processor to processor SCCs. GDPR requires that if a controller shares data with a processor, they need to enter into a data processing agreement, and the processor needs to roll that further down the chain, and impose the obligations from its data processing agreement with the controller to its sub-processor. Helpfully, the Module 2 and Module 3 SCCs cover all the requirements for a data processing agreement, which is helpful, which means that you do not have to enter into a data processing agreement. However, 2 comments on that. One, I see that in practice, companies tend to have a data processing agreement to which they annex the SCCs, which makes sense in certain situations. For example, where you have a global data processing agreement and you have specific modules for the EU, for example, then it makes perfect sense to keep your global DPA and add the new SCCs to your European section of that global DPA. But there's also another benefit to having a separate DPA, and that's in the SCC, there's a clause that says that a copy of the SCCs must be provided to the individual whose data is transferred. And this includes the right to receive the annexes. And the annexes must contain detailed information on, for example, the technical and organizational security measures, including potentially supplementary measures adopted in view of the Schrems II decision. And while you're allowed to redact those annexes, the data exporter would then still need to explain or give a meaningful summary to the individual. If otherwise, the individual wouldn't have a clear understanding of the content of the annexes, or would not be able to exercise their rights. So if a data exporter and an importer want to include information in the SCCs, that is not strictly required by the SCCs. And that could, for example, be certain supplementary measures that go beyond what the SCCs require. Or for example, a local law assessment or a data transfer impact assessment. And then the parties can keep that out of the realm of the SCCs by, out of the realm of the SCC's disclosure provision, I should say, by annexing it to the separate data processing agreement. So that's a benefit that we see in practice of having a separate DPA in addition to your SCCs. and now sort of making the bridge to operationalizing your SCCs, the new SCCs contain increased reporting and documenting obligations. So for example, data importers have the obligation to respond to access requests, but they also have a direct obligation to notify data breaches to supervisory authorities in the European Union, to the exporter, and in certain cases also to the data subject. And let's be reminded, these are companies that are outside the European Union, that are not covered by the GDPR, but through the SCCs, they sign up to reporting security incidents to a European supervisory authority. I already said they should be ready to share a copy of the SCCs with the individuals. And it means that both data exporters, but also in particular importers who are not otherwise covered by GDPR, will have to put in place adequate procedures to be able to respond to such requests or demands in a timely manner. And after the webinar, we will, together with the slides, share a document that contains all the reporting and documenting obligations under the new SCCs. And on the next slide, please, you can see a quick preview. So it looks like, but you will all receive a copy of this document to have it handy. So first question, could you please give an example of the last scenario that you mentioned? The SCCs cannot be used between an EU-based exporter and a non-EU-based importer who is subject to the GDPR. Now let's say that we'll take the this time it's not a Canadian company, but it's a Mexican travel agency that offers road trips through Mexico and targets those two individuals in the European Union. And as a result, it is subject to GDPR, because you're subject to GDPR if you are outside the EU and you target your services to people who are in the European Union. So this Mexican travel agency is covered by the GDPR. It has a partnership with a travel agency that's in the European Union, and as part of the partnership, they have agreed to share lead information or customer information, so that they can send them marketing emails, for example, or invite them to certain events. So the EU-based travel agency is the data exporter. The Mexican-based agency is the data importer, but it's also subject to GDPR. Now, for that transfer, they cannot use the SCCs because the importer is also subject to the GDPR. I hope that clarifies that question. Another question, again, related to the example that I gave. In the scenario where a Canadian company targets the EU market for road trips and uses a Mexican processor to send out marketing campaigns, how does Canadian adequacy play into the assessment that SCCs be required between Canada and Mexico? The Canadian adequacy doesn't necessarily play a role there, because the adequacy is for the transfer from the European Union to Canada. So in my example that I just gave, if that, and that's why I use Mexico, if the travel agency would be in Canada and would be under PIPEDA, then the European partner could send data to the Canadian company without the need for SCCs, because it comes under the adequacy decision. But then if a Canadian company uses a third party that is outside of Canada, so outside of the adequate territory, then it has to sign the SCCs, because it's transferring data outside of that GDPR safe harbor, if you will. if a Canadian company transfers EU personal data to another Canadian company that will retain the data in Canada, SCCs are not required because the company would be covered by the European Commission's PIPEDA decision. Is that correct? Yes, that is correct. Is there a particular regulated guidance document or other citable statement that Council can be directed that states the SCCs can be used in place of a DPA? I think there is. I think there's guidance from the European Data Protection Board that actually states that, but I can look that up and revert offline on that. And then what if data from outside of the EU is stored and processed in the EU? Will that European company be required to comply with the GDPR for the non-EU data? Yes. Yes, any company that's in the European Union is covered by the GDPR and must comply with the GDPR, also if it is non-EU data. Now, it depends on what that company's role is. If it is a controller, then the whole of the GDPR applies. If it's a processor, then only limited obligations of GDPR apply to that specific data processing activity. But if then that EU-based company wants to transfer back the data to its customer in the outside the European Union, then it needs to enter into the module 4 SCCs, as I just described, because it's a transfer from the European Union to a recipient outside of the European Union. All right. One more question. Oh, I think this is a follow-up to the previous one. Given that SCCs necessarily apply to a situation where the data of EU residents is involved, any importer outside the EU would become subject to the GDPR, eliminating the need for the use of SCCs. When would the SCCs be used then? To clarify, the GDPR does not apply just because data of EU residents is involved. The GDPR applies in 3 situations. One, if the controller, so that's the company determining why and how the data is processed, is based in the European Union. 2, if a company outside the European Union targets its services to individuals in the EU. And thirdly, if a company outside the European Union monitors the behavior of individuals in the European Union. Now, the targeting of goods and services doesn't mean that if you have someone from Germany or from France or from Spain in your marketing email list, for example, or if you have a global web shop that allows people from all over the world to purchase your products, then the GDPR doesn't apply automatically to that data. Only if you actively target people in the European Union would the GDPR apply to that data. And when do you actively target? For example, if your website is in a local language of a European Union country, if your top-level domain name is that of a European Union country, if you have your prices in euros or other local EU country currencies, if you have customer support in the local language. So those are all factors to take into account to determine if you pay search engines for AdWord advertising targeted at people in the European Union. Those are all scenarios or circumstances that could determine that you target your goods and services to people in the European Union. And monitoring behavior, so there's no targeting requirement there, but you must have the intention to monitor. So for example, if you build profiles of individuals in the EU through cookies, or if you have wearables that monitor them, their movement, for example, that will be monitoring in that sense. But the mere fact that you have data of someone that's in the European Union in itself isn't sufficient for the GDPR to apply. So the SCCs are actually used in many cases. Going back to your travel agency example, why would the EU exporter and the non-EU importer, subject to the GDPR, be able to use the controller-to-controller SCCs? They would not. Maybe I misspoke, but they would not be able to use the controller-to-controller SCCs because the non-EU importer is subject to GDPR. And the question then is, what do they use instead? Difficult. There may be specific exemptions that they could use that are also in the GDPR, but it goes a bit beyond the scope of this webinar, I think, to address all of those. Further question, and keep them coming, please. If you have a global website that doesn't actively target the EU, but you become aware that there's EU data, system analytics, does GDPR then get triggered? Sorry for the lawyer answer, but that depends. But if it's just analytics, then, as I just explained, that in itself doesn't mean that GDPR applies. But again, if you start building profiles, then the GDPR may apply. Are individuals consumers? Of course, but are companies individuals? No, companies aren't individuals, but employees of companies are individuals in the meaning of GDPR. So for example, my business email address, marc.elshof@dentons.com, is personal data in the GDPR sense of the word, and therefore would be data of what I just called individuals. I don't understand how a substantially similar provincial privacy law could displace PIPEDA with respect to the EU data received by a Canadian resident company. EU data seems to be trans-border and therefore necessarily outside the scope of any provincial legislation. Perhaps a question for the Canadian Dentons team members. Amanda, can I pass this one to you? Maybe just add from my side that indeed the European Commission's adequacy decision is limited to PIPEDA, and anything that's non-PIPEDA isn't captured by the adequacy decision.
Yes, that's exactly what I was just going to say. So I think you've I think you answered it for me. No, that's fine. Thank you.
So I hope that answers that question. Then maybe let's go on to the next slide. And this has a lot of text on it, but again, it's intended to be also a reference document you can use after the webinar. And what I would like to focus on perhaps is the drafting tips. I'll leave the other two where they are, but some drafting tips from experience with the new SCCs for the past 6 months. It is now. Start with the annexes, because they describe the processing activities, they describe the data that's involved, and then choose your TOMs, so your technical and organizational security measures. That has been a practical way that we approach it, and that seems to work well. Differentiate between your measures, so there are certain measures you have to have in place. Access control being one of them, for example. encryption is more and more a must-have, and there will always be certain add-ons or nice to have that you can apply. When doing your local law assessment, so maybe explain that a bit more detail. The SCCs have a provision, have a clause that say that the data export and data importer warrant that there's nothing in the laws of the country of the importer that would impinge on the protection offered by the SCCs. And they need to do a local law assessment, and they need to document why they believe that that local law doesn't impinge on the protection offered by the SCCs. Now you should bear in mind that this is not an adequacy decision. So you're not doing the work of the European Commission that when determining if a country is adequate in the GDPR sense of the word, look at the entire data protection framework that's in place in that country. So you don't have to look at general shortfalls or incompatibilities with the GDPR, because those are remedied by the using SCCs. That's the whole purpose of the SCCs, that you transfer data to a country that has a different level of protection, of data protection than the European Union, and you top that up, if you will, by using the SCCs. But you should focus on local surveillance and government access laws, because those cannot be remedied by the SCCs. If an importer is subject, an importer is subject to its own local laws, and if the government can say to the importer, please send me all the data you have on these and these European citizens, then nothing in the SCCs will prevent that. And that's why you need to do that local law assessment and see if you need to apply supplementary measures. And finally, practically all data processing agreements or data transfer agreements I have seen have some form of limitation of liability or some form of indemnity, depending on which side you're on. There is no definitive answer as to you can actually limit your liability towards your contracting party under the SCCs. I attended the webinar where the European Commission people that drafted the SCCs very carefully, but they did seem to take the position you cannot. On the other hand, it's a commercial arrangement between two parties, and privacy laws and the European Commission don't have the authority to limit those commercial arrangements. And we're seeing in practice that limitation of liability continues to be added to data processing agreement and it continues to be added to, or they extend to the SCCs if the SCCs are annexed to a data processing agreement. There is this boundary that the data subject's rights may not be reduced by that limitation of liability, but generally speaking, that will not be the case. And there can be very specific situations where there may be competition law aspects to it, and where there would be abuse of market power, for example. Next slide, please. Not so much a legal slide, if you will, but it's a very important one. And that's what I always advise our clients is don't forget to bring your internal stakeholders on board. And that doesn't just apply to the SCCs, it applies to privacy compliance, graph compliance as a whole. Because it's not just a legal issue, it affects the business, and you will need to have engagement from stakeholders, be it in sourcing, IT or IT security, marketing, your business groups, HR, the C-suite. Without broad support and engagement from the wider organization, you will not be able to achieve substantive compliance. Don't treat it as a purely legal issue, because then you'll end up with shiny new policies, but no compliance. It is as much a technical issue or a sourcing issue or an HR issue. And as I said, only with that broad support and engagement will you be able to achieve actual compliance. Next slide, please. Because sort of final part of the presentation, and then we can go back to some Q&A. Just wanted to briefly touch upon some of the initial enforcement actions that we have seen in relation to the new SCCs, or more broadly, data transfers after Schrems II. I've selected 5 cases, and I won't go into detail on all of them. We don't have time for that. But the gist of basically all of them is that these fines were prompted by lack of homework. Maybe they would have been issued otherwise, but in these cases, the supervisory authorities concluding that the formal requirements of the GDPR were not met, and therefore they fined this company almost 500,000 euros. Next slide. Similarly, Italy, a university was fined 200,000 euros for data transfer to the US for a number of reasons. One of them was that the documentation provided by the university as part of the investigation didn't contain any evidence of a data transfer impact assessment. And that triggered a fine, again, because the GDPR requires that you document your data transfers. Next slide. This one received, in Portugal, received a lot of, at least in Europe, a lot of attention at the time. The National Institute for Statistics was ordered to suspend its transfers to the US until a transfer impact assessment was done. So in this case, it was Cloudflare that they used. And I think you can say a lot about whether this decision is correct. But again, it shows the point that if you do not do your homework, it's fairly easy for a supervisory authority to take actions. Next slide. Germany, a company was ordered to stop using MailChimp. So there was a complaint to the Bavarian Data Protection Authority about the use of MailChimp by a company. And here the DPA took the decision based on its conclusion that the company in question had not examined whether any supplementary measures were needed on top of the SCCs in view of what the European Court of Justice had ruled in the Schrems II decision. So to summarize, because no data transfer impact assessment was done, the company had to stop using MailChimp. And then the final one on the next slide, please. This is very recent. A week or two ago, the Austrian Supervisory Authority ruled that the use of Google Analytics violates the GDPR. Now, this has again created this whole flurry of complaints and panic in the market. In essence, what the Austrian Supervisory Authority has said is the measures taken by Google are insufficient to prevent access by the US government, and therefore, and that access goes beyond what's allowed under the SCCs, to put it sort of in simple terms, and therefore that impinges on the protection offered by the SCCs, and therefore you cannot transfer data to Google in the US. And this is one of the first decisions where a supervisory authority actually looked at the merits of supplementary measures in this case Google, and concluded that they were insufficient. This case is the result of a complaint filed by None of Your Business, which is the privacy activist group behind which Marc Schrems of the Schrems II decision stands, and they filed 101 complaints on data transfers. So we're waiting for further decisions to be taken, and there are 2 pending before the Dutch supervisory authority, and they also, in anticipation of those decisions, already said that the use of Google Analytics may perhaps soon no longer be allowed. So that doesn't bode well from that perspective. And I mean, my concern with this decision is that it may turn what's a data export law into the data localization law, and I think that's it's in stark contradiction to the GDPR recognition of the need for international flow of data, and I personally feel that it is the wrong direction. I don't think that company or countries or regions should build high walls and oblige companies to store their data locally. And I think it's incumbent on supervisory authorities and decision makers to carefully consider how disruptive decisions like this can be in the real world. To many functions on the internet, including for SMEs, for example. I mean, one thing is certain: Schrems II, data transfer, impact assessments, they're here to stay. And if you look at the previous 4 cases I discussed, they were all about accountability, about having your narrative in order, about having done your homework. So even if you may not be able to achieve 100%, building your story and documenting all the effort that you have taken will help in your conversation with a supervisory authority if it comes to that. And on that positive note, I'll hand over back to Amanda for some final Q&A, I think, in the last 5 minutes of this session.
Yes, absolutely. So you had mentioned in your discussion earlier that the SCCs need to be executed as is. What about the annexes? So you mentioned a little bit that some information can be contained in the annexes, but so for example, like how much detail should be in there? Do those have to appear exactly as they do in the SCCs, or is there some wiggle room to change those? What tips do you have for us when completing the annexes?
So the structure of the annexes is fixed. And so there are 3 annexes to the SCCs. The first one basically describes the data processing, describes the parties involved. It describes the categories of individuals, categories of data, whether they're sensitive data, the frequency, the purpose of the processing, etc. So those need to be completed. The second annex is on security measures. Now that's of course free form because you need to put down there the actual technical and organizational measures that you take. But it's quite a long list of possible measures. So that's an indication as to what the European Commission is thinking about in terms of appropriate measures. And the third annex is a list of sub-processes. So format is fixed, contents are to be determined on a case-by-case basis.
Okay, and you had mentioned, you made a great point that, sometimes you have these like shiny, nice contracts that you've signed and then you're excited they're done, you put them in a drawer and no one ever looks at them again. But compliance is more than just having the document signed. So are there any sort of overarching tips or things that you think people should keep in mind when they are doing an overall data protection strategy? Because I know the SCCs are only a small part of that.
Yeah, I think it ties in with my previous point around engaging internally with other stakeholders. I think especially for global companies or companies operating in multiple regions, it's important, I think, to take a holistic view to data protection and not just look at the GDPR in isolation or the SCCs in isolation, but try to embed it in a broader privacy framework where you can perhaps take the GDPR level of protection as your benchmark, because it's still typically the highest level, but be flexible where it's not needed. Or maybe, and I also have clients that take that approach, we just apply GDPR across the board because that puts us in a safe spot everywhere, and we maybe have some local add-ons where needed. But my two tips would be engage with a broader audience internally and take a holistic view to data protection.
That's very helpful. Thank you. I see we have Chantal back.
Well, we only have 2 minutes left. I want to thank Marc. This was of such practical value, but I noticed that there are outstanding questions. So I want to tell the participants that we will find a way to actually complement the materials that we will send, because you will have access to the slides that Marc and Amanda had prepared. And so we will also try and include in that answers to the outstanding questions. There are 4 points that I feel are takeaways. The very first one is we need to prepare now, because a timeline of December 27th is really a recipe for chaos, if not disaster and failing. A second thing that I draw from Marc's presentation is that it's still in flux, and therefore we really should keep a watch on the interpretation of the application of the SCCs. Thirdly, I noticed how many of you are surprised that provincial, substantially similar legislation to PIPEDA would not receive adequacy. Well, the fact is that actually Quebec did apply for adequacy and was turned down a few years ago. So definitely there is a distinction. And so finally, I would like to remind us that risk assessment in cross-border data transfers are not just a European requirement. If you look at the OPC 2009 guidance on cross-border data flows, it clearly states that the OPC expects, on the basis of the principle of accountability, to do a risk assessment of the countries to where it cross-border transfers data, to make sure that that country does not have a legal regime or a political situation that would undermine the protection of the personal information. And then we have Bill 64 that is now introducing, when it comes into force, the privacy impact assessments for cross-border data flows. So it is truly a new privacy risk to manage. So on that, because we are exactly on top of the hour, Amanda, thank you so much for making this happen. Marc, thank you so much for your generosity and expertise. To all of you, we will follow up, and we hope to be able to answer the questions as you have them to your full satisfaction. Thank you all very much, and enjoy the rest of the day.
Thanks all.
Thank you.
Bye-bye.